post-grant, post-registration. We talked a lot about all the work I'm doing in researching and applying for. We just got done talking about all those oppositions, but let's say the champagne cork has been popped, you've got the registration on the trademark side, or you've got the patent now granted, fully granted. What are some things that are coming, right? What else should I be thinking about as a trademark holder looking ahead? Matt, I'll start with trademarks and we'll go to the patents.
Yeah, no, good question, right? So I think, if you have a trademark registration, the first thing to do is make sure you update your branding to reflect the fact that you have a registered trademark. So put the circle R on the most prominently displayed, parts of your brand. So maybe the website, maybe the products, right? Maybe the footer of the website, any marketing, advertising, like at least the first time you use the brand, put the registered trademark symbol behind it. That's important. If you're an online seller, I'd recommend, getting the Amazon brand registry process started. That's kind of a pain, but if you have a registration, Amazon will allow you to participate in its brand registry, which gets you a bunch of really great benefits, like custom landing pages for your products, pictures, videos, additional colors, copy, that sort of stuff. That's a big thing that you should look at doing after you get your registration. If the reason you've registered your product in the first place is because you're getting knocked off, you can obviously contact Customs and Border Protection. And if you have an idea of where the products are coming from, or when they're supposed to arrive, you can have CBP basically take those products and put them aside, and they go through a process for trademark infringement.
As the owner of the trademark, is it something that I would want to do, or should I hire counsel to help me?
You're definitely going to want to hire someone who deals with CBP.
CBP.
Yeah, Customs and Border Protection. Cool. Your typical trademark attorney like me, not going to know anything about working with them.
Okay.
But somebody who works with customs, imports, exports all day should have a pretty good sense of how to do that.
Perfect. And if anyone has a question here, if they had, would you be able to send them off to someone that could help them out? Do you have a referral partner that can do that?
Yeah, we can find someone.
Perfect.
And then beyond registering the trademark with Amazon and maybe CBP, you could also just put the renewal dates in your calendar. That's an important thing, unless you're working with an attorney and they have a docketing system, in which case we'll docket it for you.
Yep.
But that's really it.
Cool. I wanted to show
one last thing. I'd also recommend that you put a Google alert. You create a Google alert for your brand, for your registered trademark.
Ooh,
so that if you do see somebody else, or somebody else is using a similar brand or the exact same brand, you're going to get notification. That's going to be the easiest way for you to police your brand. Is just do a Google alert. If anything kind of comes up under that brand, you're going to get notified, in which case you can reach out to your attorney. Yeah, because most clients, including the vast majority of our clients, are not going to want to pay a law firm to quarterly or monthly police the trademark. They're just not going to do it because it's not going to be worth the money for the most part. Yeah, so trademark maintenance. So you get the trademark registration certificate. Yay, champagne corks, confetti, yada yada, rainbows from unicorns flying everywhere. So what do you have to do then, right? So your trademark rights subsist upon use in commerce. So you need to continuously use the trademark. So if you stop selling products for a year or two, you potentially abandon the trademark, depending on the vertical that you're in, right? But that being said, you do have to renew the trademark during specific statutory time periods. So post-registration, between years 5 and 6, you need to renew the trademark by filing what's called either a Section 8 or Section 8 and 15. We'll talk a little bit about that in a little bit. But so between years 5 and 6, years 9 and 10 post-registration, and then every 10 years thereafter.
Okay.
So, 3 times in the first 2 decades, essentially.
Yeah.
One of the things that clients ask about, or we typically recommend to clients, is that when they file their first renewal during that 5 to 6 year time period, we file what's called a Section 15. Section 15 is a document. It's basically money to the USPTO, but in return for that, you get what are called incontestable trademark rights, meaning that a third party can no longer challenge your trademark for a variety of really important reasons. Some of the more important reasons, like priority of use, some of those things that you could potentially your trademark could be canceled for. If you file the Section 15, it precludes third parties from filing cancellations under those grounds. So really
Wow.
important, especially in highly sought after trademarks or competitive fields,
Right.
or where you might know that there's a third party competitor out there who's
Yeah.
doing something similar, right? Maybe they have priority of use over you, but you want to make sure that at the end of the day, like they can't come after you for trademark infringement. Section 15 is the way to go.
That is huge. So you can kind of, in a way, strategically do it. If the other party is, call it being lazy, and they're not monitoring the market as they should be, they didn't notice you. And it's kind of like, the old property statute, adverse possession. Like, hey, I've been here,
Yeah.
prominently selling my product, right?
I think of like a Section 15 filing as more like a defensive measure than offensive. You would never have a Section 15 and then use that as a way to kind of enforce the trademark, but it prevents maybe a senior user from enforcing its unregistered trademark rights against you as the junior user who did the right thing and filed the trademark. After 5 years of public notice, you filed the Section 15. So you've done everything right as the junior user. That should not allow the third party senior user who slept on their rights to enforce the trademark against you.
Right.
So it's really a good peace of mind thing, and it's only a couple $100, so generally it's worth it to most clients.
Very cool. Speaking of that, let me put that quickly in here. And Matt, while you were talking, I was thinking about our own brand here at Bold, and it's not like you file your app, your trademark, and it just is locked in forever. Markets change, right? The way you market your company changes over time. So isn't it correct? You should probably check in and see maybe now you're moving toward a different brand and refiling and kind of staying on top of it as your company grows.
Yep. And a lot of clients too. I mean, I have a number of clients who's they've been in business for 40, 50 years, right? And like we still monitor and maintain their trademark portfolio, but they have lots of legacy trademarks before the USPTO did electronic filing. So you have like scanned PDF Xerox copies of like old logos back from like the 80s. As long as you're still using those in some fashion, you can continue to renew the trademark registration. But at some point, if you're no longer using that particular brand and you're already registered for the new brand, new logo over here, maybe you have a word mark that goes back to 40, 50 years. At some point, maybe it's worth just giving up those old registrations.
Right. But there doesn't make any sense necessarily to file like a non-use, or just you just stop using it.
Right.
You want to go back to it and kind of
exactly. So most clients want to keep them if it's possible to keep the old trademark registrations, but of course they still have to use them in some capacity in order to legitimately say they're still using the trademark.
Some initial things that come to mind as soon as you get the patent granted, just know that you finally are able to enforce your rights. And I think, as Matt alluded to and talked about, is there is no such thing as a USPTO police. No one or no company, individual, or government is going to go spot and monitor for infringement. That's on you. That is a huge pill to swallow for some of those inventors that didn't quite realize that now they're on the hook to go watch and stay active in the market and go look for those products, systems, methods, processes that might be infringing. So for you to be able to have that time, right, to make an effort to go look for those, make sure that's part of your plan, your business plan. Generally, inventors I speak with have one of two major routes that they go down. One is a much more passive route toward making money, and one is more active. The passive route is one where you're looking to just hold your rights and or transact with your rights via licensing or outright sale of your patent or patent portfolio if you've been fortunate enough to file more than one. And that can happen through licensing, right? Going and hiring a broker, or you yourself going on meeting some people. Maybe you already know people that may want to use your technology, build it, make it, use it, sell it. And you can construct contracts with lots of different types of clauses, with a lot of different arrangements to allow you to make money, say on a royalty basis, or on net proceeds, or you make a flat amount of money for every unit that's sold. Lots of open negotiation there. And we have just recently hired on, Matt, if you knew Cliff Schlecht. Cliff has joined Bold. He's a patent licensing attorney. That's what he does.
That's cool.
And and there's lots of stuff that happens between inventors and universities, technology transfers, a lot of nuance I won't necessarily have time for today, but post-grant, that's when you start making money. Now, certainly you can start selling, and we encourage sometimes to do that while the patent is pending. And one of the benefits there is that you hit the ground running, before before that clock starts. you can actually be in the market already and be in the know about infringers. So as soon as that rights get granted, maybe you've already warned potential infringers and they said, you know, screw you, wait till you get a patent. Now you can go hire litigation counsel and get them for triple damages because they're willfully infringing.
Correct.
Lots of cool benefits to enforcement side. And what's neat is over the past year or two recently, Matt, I've gotten close with Josh Van Hoven and there's a few other attorneys that do patent litigation and represent the small gal, the small guy. And you can actually do it. It's not this classic scenario of David versus Goliath. You know, I talked about it when I was on with David that there's this huge win. Apple, right? The largest company, $1 trillion company, was strangleheld by their Apple Watch sitting at customs because they were violating a patent on the oxygen sensor. A little company in the Bay Area, I mean, they're a couple $1 million company, but that's little compared to big behemoth. The customs said, nah, we're holding this. And they were not allowed to sell any of their Apple Watches. So there's a huge benefit.
I remember hearing about that. That was a couple months ago, wasn't it?
It was recent, yeah. And so they finally settled. They were holding out, but it was like a 6-month deal. They got paid. Those inventors, the company that made the innovation, it was owed to them. So shame on you, Apple, and those big companies. There is a win. There's a path forward. You don't need to have, you know, treasure troves of money to go pay litigators. The system is set up to reward those that have the rights. So enforce them.